Manila Prince Hotel vs. GSIS. GR number 122156, February 3, 1997. Facts: pursuant to the privatization program of the government, Respondent Government Service Insurance System or GSIS decided to sell through public bidding shares of the Manila Hotel. There were two entities who participated in the bidding: petitioner Manila Prince Hotel or MHC, a Filipino corporation, which offered to buy the shares at 41.58 pesos per share, and Renong Berhad, a Malaysian firm, which bid for the shares at 44 pesos per share. Eventually, MHC matched the bid price of Renong Berhad at 44 pesos per share. MHC even sent a manager's check to GSIS, which the latter refused. Apprehensive about the refusal of the GSIS, MHC filed a petition for prohibition and mandamus before the Supreme Court. MHC invokes Paragraph 2, Section 10, Article 12 of the 1987 Constitution, commonly known as the Filipino First Policy, where it states that in grant of rights, privileges, and concessions covering the national economy and patrimony, the state shall give preference to qualified Filipinos. In the same vein, MHC submits that Manila Hotel has become a part of the national patrimony for its importance in the national Filipino heritage. Also, the ownership of shares by the GSIS shows that they are engaged in the hotel business, which makes them part of the national economy. Thus, the aforementioned constitutional provision can be invoked. Further, MHC should be considered the preferred bidder since the bidding rules provide that the shares must be awarded to qualified bidders in case the highest bidder cannot be awarded the same, provided that the qualified bidders match the highest bid. On the other hand, GSIS maintains that Paragraph 2, Section 10, Article 12 of the Constitution cannot be invoked because it is not self-executing and would require an implementing legislation. Granting that the said provision is self-executing, the Manila Hotel cannot be considered a part of the national patrimony because it only refers to lands of public domain, waters, minerals, etc. Further, granting that Manila Hotel is part of the national patrimony, GSIS is not selling its land or the building, but its shares of ownership. Issue number 1. Whether or not Paragraph 2, Section 10, Article 12 of the Constitution may be invoked as a self-executing provision. Held, yes. The Supreme Court admits that a provision which lays down the basic principle, such as those found in Art. 2 of the Constitution, is usually not self-executing. However, the court also held that a provision which is complete in itself and becomes operative without aid of an enabling legislation, or that which supplies sufficient rule by means of which the right it grants may be enjoyed or protected, is self-executing. Thus, a constitutional provision is self-executing if the nature or extent of right conferred and the liability imposed are fixed by the Constitution itself. Paragraph 2, Section 10, Article 12 of the Constitution is mandatory, positive command, which is complete in itself and requires not further implementing laws for its enforcement. Thus, it may be invoked by MHC in the present case. Issue number 2. Whether or not Manila Hotel can be considered part of the national patrimony in order for the aforementioned provision to be applicable. Held, yes. The Supreme Court held that national patrimony includes the national resources of the Philippines, which necessarily includes those which are considered cultural heritage of the Filipinos. Since Manila Hotel itself has become a landmark of many events in the Philippine history, with its existence impressed with public interest. Thus, the contested constitutional provision is applicable. GSIS, MHC, Committee on Privatization, and the Office of Government Corporate Counsel were directed to cease and desist the selling of shares to Renong Berhad, and to accept the matching offer of Manila Prince Hotel Corp.